Welcome, everyone. My name is Thad Adams. I'm a partner at Shoemaker, Loop & Kendrick in their Charlotte, North Carolina office. Trust everyone is well and safe. I understand we may end up with about 60 participants today, which I think is excellent. This presentation will last about 1 hour, and there will be time for some questions. And I understand that on the screens that the attendees are looking at, there's a box. And if you want to ask a question, you can simply type the question or the comment in a box, and it's supposed to show up on my screen. So we'll see how that works. Let me start by giving you some background about how this program came about. Going back for some years, Shoemaker has been fortunate to handle a variety of significant patent, trademark, and copyright litigations. In some, we represented accused infringers. In others, we represented IP owners with infringement claims. These cases were significant, both in the complexity of the profits and damages issues presented, and also the potential for recovery or liability. And given the fact that we were, in some cases, representing infringers and in other cases representing IP owners, I think we gained an objective view from both ends of the spectrum about how these issues played out. It's not like we were only representing IP owners or IP infringers, and therefore our thinking was skewed one way or the other. I think that just sort of the way it happened, we came up with a very good balanced understanding of how some of these issues resolve themselves. And in most of these cases, there was enough at stake to require extensive preparations, experts, surveys, demonstrative exhibit creation, extensive discovery, pretrial motions, including summary judgment. And in many of these cases, we had the opportunity to work with some truly excellent in-house counsel. For example, Paul White, Luther Moore, and Stacy Gray at Belk, all fine lawyers who we thoroughly enjoyed working with. Stephen Duke at Dillard's, Tim Blackburn at Variety Stores, Nicole Farrington at Firebird's Wood-Fired Grill, John Engenberg at General Wig Corporation, and going back a bit further, several at Time Warner Music and Warner Electra Music. The Shoemaker team in this, for most of these litigations, included our truly excellent paralegal, Cecilia Sidebottom, who has been with me now over 20 years, and attorneys Christy Tremor, Alex Long, and Tom Bingara, all of whom have done much excellent work. So this presentation captures some of the ideas and statutory requirements that control how profits and damages relate to each other in patent, trademark, and copyright litigation. And my goal is to be as specific as reasonable about how these cases played out. So before we get started, here's the usual disclaimer. I'm not presenting this as an attorney representing any client, specifically any of those that we'll be discussing cases for. Nothing said here is intended to stake out any position regarding how a case should have turned out or in one case will turn out. And particularly regarding the Variety Stores, the Walmart trademark infringement action, some of you may have attended a seminar last year where this case was discussed in some detail. Well, that case was on appeal by Walmart, and it's been caught up in the COVID-19 events of the past several months, and at present has an unknown status in the Fourth Circuit. It was actually scheduled for oral argument on the week, I think included May 8th, and it was taken off the calendar, and at the same time, the Fourth Circuit entered an order saying that they were abrogating a general rule that they would not issue dispositive or precedential cases in particular cases unless there had been oral argument. And they said in some cases we're actually going to decide these cases on the brief, and they made some comment to the effect that they assured us that they would exercise the same jurisprudential rigor as in any case where there was oral argument. Subsequently, they set some remote oral arguments, and for whatever reason, the Walmart Variety v. Walmart case was not one of them either. So I think the terms are over now for the Fourth Circuit until the fall. So my expectation is that we'll either get a written opinion of some sort, or I suppose it's possible they may simply kick this over and set it for oral argument in the fall term. We'll just have to wait and have to see what happens on that. Feel free to look me up and call with any questions or comments you have. I'm easy to find. If there's something that you want further discussion about, I'd be happy to talk to you about it. So with that as background, let's go ahead and then dig into this a little bit. I'll get a few dings here. Okay, speaking both from the standpoint of the property owner, the IP property owner, and the accused infringer, why is this important? Well, obviously, from the standpoint of the property owner, if you're considering bringing some type of action, you want to know what remedy is best suited to the particular circumstances in a given case. There's always a question of relative risk. That involves doing a fair amount of due diligence, understanding the financial liability to the company if the claim is unsuccessful, and also gaining some understanding of the difficulty of proof. And similarly, with regard to the accused infringer, there's a question of relative risk, whether to settle or to fight. You always want to at least consider whether a license might be available. Due diligence, as with the IP property owner, is always quite important. Question of financial liability, if the claim asserted against the infringer is successful. And again, there's a question of difficulty of proof. And that's a particular issue with regard to accused infringers, because as we'll see, in typical form, the way the statutes are written is that the burden of proving deductions from profits is almost always on the infringer. And so in a worst case scenario, when the IP owner puts into evidence the infringer's gross revenue, at that point, if the infringer doesn't come forward with credible evidence regarding deductions, the IP owner, the profits are the gross revenue. And so that's a serious issue that we've certainly had to consider in a couple of cases that we'll talk about in a few minutes. So the order of discussion, we'll talk about patents first. The statute, the patent statute, is very different from the trademark and copyright statute. And before we get into the details of the damages issue, there are questions of venue and transfer that enter into where to file and how to defend. Proof is different than in trademark and copyright cases. And also appeals in patent cases are to a different Court of Appeals, the Federal Circuit Court of Appeals. They have their own way of doing things, and they get shot down pretty regularly by the Supreme Court in a couple of cases we'll see in just a few minutes. But it is a different situation than going to a regional circuit. You're pretty much stuck with a single body of law, and chances are there's going to be a pretty narrow selection of judges on the panel, and easy to figure out what the operative principles might be, since these same judges are writing opinion after opinion after opinion. So regarding venue, there was a recent game changer in this area. About 20 years ago, the Federal Circuit decided that they thought that the patent venue statute, 28 U.S.C. section 1400B, was too narrow, and took the Supreme Court 20 years, but finally in the Heartland v. Kraft's Food Brands case, the Supreme Court decided that the Federal Circuit rule had not really worked well, and so they backed off of it. Now, prior to the case in T.C. Heartland, the Court of Appeals for the Federal Circuit had broadly interpreted the language where the defendant resides in the first prong of the patent venue statute as meaning any court having personal jurisdiction over the defendant. Under this interpretation, the proper venue for a patent infringement case was essentially anywhere a defendant conducted business. And this broad interpretation greatly facilitated forum shopping. It became very customary for, quote, plaintiffs, close quotes, to go out and accumulate bundles of sometimes worthless patents and assert them in a very unfavorable forum for the defendant, and use it essentially as extortion, a polite form of extortion. So the Supreme Court came along in T.C. Heartland, and now they limit the residence of the defendant to the state of incorporation of the defendant for purposes of proper venue. That typically kicks the case over into the second phase of the statute, which says that where they have a regular and established place of business and where an active infringement has occurred. So the forum shopping has been substantially curtailed. You see this map of Texas, this little section in the northeastern part of Texas. At one point, I think it's correct to say that almost half of all the patent infringement suits in the United States were located in this one district. And the reason is that some very early lawsuits were filed, and for whatever reason, some local juries in these small towns, it almost became a cottage industry to go into some of these, sit as jurors on some of these infringement cases and just see how high they could push the damages up. And it became almost a game to see who could trump whom. It got so bad that a lot of the larger law firms, IP firms in the country, went to these small towns and opened up satellite offices, or soliciting business and really creating havoc in the patent bar. So we can see here under the evils of forum shopping. Now, under the T.C. Heartland case, the regular and established place of business requires a regular physical presence of an employee or other agent of the defendant conducting defendant's business in the alleged place of business, which in most cases has kicked cases out of the Eastern District of Texas. There was a case, a fairly recent case, involving Google, and they had a search engine operation there, but they did not have a regular and established place of business, according to the court. They had no employee or agent actually or regularly conducting his business within the district, and so the court held that the Eastern District was not a proper venue for patent infringement. This was a petition for mandamus, and there were quite a number of these that were filed over the years. Most of them were unsuccessful for various reasons until the T.C. Heartland case. And since then, there still have been a fair number of suits brought in the Eastern District, but the courts have been more attuned to the position of the accused infringer, and some of these petitions for mandamus are being granted. So, for example, Google won a case this year. And the question was whether or not Google had an employer agent with a regular physical presence at its place of business, and whether that employer agent was conducting Google's business. And the court said it was clear that they weren't. It sort of left open the question of whether or not there was an internet service provider acting as Google's agent, but in this case, they concluded that there wasn't sufficient evidence that there were. So even though Google is obviously one of the largest companies of this type in the world, they were able to extricate themselves from the Eastern District of Texas by filing this writ of mandamus. Now let's look at the patent statute. I think that should say 35 U.S.C. section 284, not 25. So upon finding for the claimant, a court shall award the claimant damages adequate to compensate for the infringement, but not, in no event less than a reasonable royalty for use made in the invention by the infringer. This clearly says that you're not going to be able to recover profits, at least not in a direct way. And so the goal in a patent statute is to determine what the patent owner's damages have been. But even in the case where it's not possible to directly establish damages, you're in no event entitled to a reasonable royalty. Second section of the statute says that when damages are not found by a jury, the court shall assess them. Actually, as we'll see in just a few moments, there's been some Supreme Court litigation about this. And actually, the patent owner has a right to a jury trial, notwithstanding the language of the statute. So the only way the court gets to determine damages in a patent case is if either the parties agree that they want a bench trial on damages instead of a jury trial, or if for some reason the defendant chooses not to file a jury demand, in which case, of course, the right to a jury is waived, and the judge, if he chooses to, can decide the case himself. He can also say, well, even though the defendant did not ask, or the plaintiff did not ask for a jury, or the defendant, the court can go ahead and allow a jury to decide the case anyway. And in some cases, the courts will do that, and they will treat the jury verdict as advisory, meaning that since there was no actual right to a jury trial, the court thinks the jury got it wrong, it can go ahead and either increase or decrease the award by whatever it thinks is justified under the circumstances. So I want to talk for a minute. You know, I wanted to be as specific as possible in some cases, and instead of just talking in the abstract. There was a case we handled some years ago, Belmont Textile Machinery Company versus Superba. And Belmont owned a patent on a specialized type of machine that involved a method for dyeing carpet yarn. A very narrow niche market. In fact, it was a two-supplier market for these dyeing machines. The industry was such that either Belmont sold the machine or Superba did. So Superba infringed the patent. None of Superba's profits were recoverable under the statute. So the question is, how was Belmont damaged? How did Belmont prove its damages? Well, remember, this was a two-supplier market. We offered evidence that sales made by Superba would have been made by Belmont, but for the infringement. And we actually had some executives from Mohawk and Shaw come in and testify that, yes, well, we would have bought the Belmont machine, but for the Superba competitive machine. It's very important here to do a careful analysis of the cost of manufacture, fixed and variable costs. And Belmont made this relatively easy for us because they had a very sophisticated labor software package, which meant that when a Belmont employee was working on a particular machine, he was punched in, so to speak, in the computer. So the computer was actually monitoring the amount of time he was spending working on that particular machine. So it was quite easy to go back and capture some very specific information about cost of manufacture, fixed and variable cost, and so forth. We also had a very good expert witness, an economist, he's retired now from NC State, named J.C. Poindexter, who did a truly remarkable job of, first of all, analyzing all of these costs, and then had the jury eating out of his hand. I mean, he really did a spectacular job of bringing this somewhat complicated case down to the level where the jury had a good idea of what was going on. So there was testimony of actual dollar amount of damage to Belmont caused by infringing sales to Superba. we really made, under the circumstances, we really did not need to put forward any evidence about what we thought a reasonable royalty would have been, because the damages that we sustained were actually quite a bit more substantial, as you'll see here in a few minutes, than any type of likely reasonable royalty would have been. So the Belmont damages had several components. First of all, there was the value of a specific patented process, which was actually a relatively small part physically of this very long die line, which was well over 100 feet long. But the importance of the process was the process carried out by this patented component, which in effect was very little more than a laptop, which included a random number generator, which conveyed information to these rolls, which dipped down into and out of dye baths and then applied spots to this yarn. And the importance was that by doing it this way, it made it truly random, so that the carpet later on didn't show up with long diagonal strips called chevroning, which is generally in the carpet business considered to be a big defect. And it was one that had caused a lot of problems for Belmont and Superba in the past. And Belmont was the one that finally figured out how to do this. But in terms of the actual cost of the laptop and so forth, in regards to the total cost of this die line, it was a very small percentage. So one of our keys was to focus on the other equipment Belmont did not sell because of the loss of the sale of the computer that carried out the process. And again, because the laptop, the computer, was a relatively small percentage of the cost, our argument was that, well, if Superba had not been infringing the patent, then Belmont would have sold several $100,000 of additional textile manufacturing equipment for each of these die lines that it would have sold, but for the infringement. So we had no evidence of what a reasonable royalty would have been, but there were some things that we took into account. One thing that you'll see in the case law is that what a reasonable royalty is to an infringer is higher than what a reasonable royalty is to a voluntary licensee. And when you think about it, that has to be right, because if the accused infringer could get the same reasonable royalty that he could get by going to the patent owner in the first instance and getting a license, and where's the incentive not to infringe? And so you typically see this when you're talking about reasonable royalties in a litigation context. That number is almost always going to be higher than what the reasonable royalty would have been if there had been an actual arm's length negotiation instead of litigation. So this reasonable royalty idea is a legal fiction that's designed to assist the courts in fixing damages where there's been a failure to prove general damages. So a determination of a reasonable royalty requires consideration of a large number of factors. And there's a case called the Georgia Pacific case, which purports to lay out about 15 different factors which you're supposed to take into account in determining what a reasonable royalty is. But those factors really are almost never very helpful. Typically, this analysis collapses down into 2 or 3 different categories. The most often one being similar situations where royalties have been awarded. There may have been licensees that either the patent owner or the accused infringer had entered into in the past, which provides some type of baseline as to what a royalty might be. And again, in that case, the number would likely move up. So in a given case, how do you get to reasonable? Well, the final amount does not need to be mathematically exact. The law simply is that it can be estimated, and it needs to be based on some type of reasonable approximation. Damages can be based on some type of annual rate for each year of infringement. or it can be a single fee for the infringement, a percentage of the infringer's sales or profits at a rate of the infringing device sold or used by the infringer. The actual profits made by the infringer, however, should not enter into the court's prospective evaluation of the infringer's profits to be allowed under a hypothetical royalty, simply because the infringer's actual profits are, under the statute, are not available. And there are a number of reasons for that. I think generally, if you go back to the legislative history, you'll find out that there's a million different ways for a patent infringer to make sure that there are no profits. And so if you spend all your time looking for the defendant's profits, many times you simply won't find any, or the amount becomes so argumentative and speculative that you're left up in the air as to what the result might be. I mentioned before about the fact that Belmont's laptop was a very small percentage of the price of this extensive die line. And sometimes that's called convoying, meaning that the sale of the infringing item may have caused increased sales of other products sold by the infringer, or may have caused other sales of other items by the patentee. And that's certainly something to take into account in determining both damages and a reasonable royalty. Again, that question was answered in a similar manner in the Belmont case, because the best of our evidence was that Belmont would have sold several additional machines, and the profits in the aggregate on the entire machine would have been quite a substantial number. So the patent statute says that when the damages are not found by a jury, the court shall assess them. And as I mentioned just a moment ago, the Supreme Court decided that, well, that's a violation of the Constitution. Under the Constitution, any claim for damages, there's a right to a jury trial. So the court does have a right to increase the damages up to 3 times, though typically based on a finding of willful or egregious conduct. Not required, but it's typically the case that that's what they find. And the justification for this is that willfulness is generally considered to be a equitable remedy, and therefore it sits outside the requirement for a jury trial on damages. As I mentioned earlier in another context, the judges will sometimes give a willfulness issue to the jury and ask them to decide whether or not the infringement was willful. And then they can, and typically will, follow the jury's guidance on that, but have a right in a given circumstance to decide that the jury was incorrect and that the infringement was not willful. And in fact, that happened in the Belmont case. The jury decided that the infringement was willful. We thought we were going to get treble damages, but district court judge in essence said, well, there was plenty on both sides. This was an ordinary garden variety commercial dispute between two somewhat bitter rivals. Belmont, the smaller U.S. company, and Superba was a much, much larger French-based company. And I think the judge may have had in mind a little bit that the jury may have done a little bit of home cooking against Superba. So he decided that willfulness would not stand. So we still ended up with quite a nice judgment, but not as much as it would have been. So there was a recent case, what I'll call the Halo case. The Supreme Court went back and took a look at the Seagate case, which is one that the Federal Circuit had decided quite some time ago. And they had, the Seagate case had quite impermissibly restricted discretionary standards or statutory standards granted to the district courts. And the Supreme Court felt like that this had the effect of insulating some of the worst infringers from punishment. So they came in and they loosened the standard quite a bit. They essentially said, in so many words, that the district court has a right to exercise its discretion in awarding enhanced damages. Going on to say, however, that this discretion has limits, that discretion is not a whim and should be exercised in light of the circumstances underlying this statutory grant of sound principles, and limit the award of enhanced damages to egregious cases of misconduct beyond typical infringement. So it's a fairly recent case. The Halo case is the law of the land now, and it has, not sure it's had any real effect on the way the district courts are handling these issues, but they do have a certain amount of additional leeway based on this relatively recent Supreme Court authority. Now, before we get into trademarks and copyrights, I need to say something about design patents. We typically, or frequently, forget about design patents. They're sort of off in the corner. And for years and years and years, design patents were very, very infrequently litigated. Starting about 10 or 15 years ago, that has started to change. And now under design patents have become quite popular. The interesting thing about design patents is that with a design patent, as opposed to a utility patent, the infringer's profits are what you get if you choose to go that route. So it's an alternative remedy, but it's actually obviously the best way to go if there is any profits. And in fact, as you'll see, as in the copyright and trademark cases, you start out with the proposition that the gross revenue of the infringer are the profits, and it's up to the infringer to come forward and start making deductions from that number. So there are a number of advantages in pursuing design patents. First of all, design patents, as opposed to utility patents, are very inexpensive. Why? Because the claim of a design patent is always just one claim. It's the drawings. And so you're simply looking at the drawings, you're comparing the drawings of the design patent with the accused product, article of manufacture, and coming to a conclusion regarding whether or not they're similar enough. There's also a relatively low standard of examination in the patent office. The vast majority of design patents tend to float through the patent office relatively quickly and without a lot of examination. I think part of the reason is that with regard, as opposed to utility claims, of course, it's possible to go in with utility claims and you can narrow the claim, you can broaden the claim, you can put limitations in, you can reword claims. You really can't do any of that in a design patent. Basically, you have views which show the design features, the ornamental features of the useful article that's being patented, and you're stuck with that. So I think there's a tendency for that reason for the examiners to simply let it through, figuring that, well, if they let something out that probably shouldn't have been patented, then leave it up to the infringer to take it and deal with it. The usual defense in the case of a design patent is that the items that are alleged to be ornamental are in fact functional. And under design patent law, you're not entitled to argue that functional aspects of the design patent design are the sort of the point of novelty and therefore what determines infringement or not. You actually have to filter out the functional aspects of what's shown in the drawings to get at what the ornamental part is. That results, of course, in a more subjective infringement standard, which I'd say makes it a little bit more difficult for the accused infringer, who's usually sitting on the opposite side of the courtroom from the jury and starts out at least wearing a black hat. So actually in a situation, in most situations, the similar standard to trademark infringement. In other words, is the design of the accused product so similar to what's shown in the design patent that there would be a likelihood of confusion? In other words, someone would look at it and think that it belonged to the owner of the design patent instead of the infringer. So under Section 289, you are entitled to the infringer's total profit. So There are some provisions here that allow you cannot recover enhanced damages if there's willful infringement. Design patent owner must prove lost profits or reasonable royalty to be entitled to enhanced damages. A design patent owner cannot recover damages under Section 284 plus the profits of the infringer under Section 289, but must elect one of those remedies. And that's sort of an odd way this statute works, because theoretically, at least, the design patent owner has a right to recover damages under both Section 284, which is the general patent damages section, and also under the special design patent section 284, or 289 rather. So the infringer's profits in a design patent are treated somewhat analogously to area of copyrights. The infringer's profits are generally calculated by initially assuming that profit equals gross revenue and then deducting allowable costs. The burden of establishing the nature and amount of these costs, as well as their relationship to the infringing product, is on the infringer. Very similar to what happens in the trademark and copyright section. So we'll move forward now to trademark and copyright. So, attributable to the infringement, question mark. Attributable to the infringement is not one of the factors used by courts to determine liability in trademark cases. So really just have to read the statute. When a violation of any right of the registrant of a mark registered, etc., is found and subject to principles of equity, the trademark owner has a right to recover defendant's profits, any damages sustained by the plaintiff, and the cost of the action. Those are cumulative. You get to recover defendant's profits. You also get to recover any damages you've sustained, plus you get to recover the cost of the action. So you see, in this is a trademark statute. There's nothing here that says that any of those profits have to have resulted from the fact of the infringement as opposed to some other factor. We'll see that's quite different from the copyright statute. Trademark statute, it says the court shall assess such profits or damages or cause the same to be assessed under its direction. Again, the Supreme Court has said can't do that, at least with regard to damages. You have a right to a jury trial. In the trademark statute, the plaintiff is required to approve defendant sales only. The defendant must come forward to prove all elements of cost or deduction claimed. But does deduction include a deduction of all or part of the profits because they resulted from some factor other than the infringement? Well, before we get into the copyright, there's a distinction in my mind, at least, between the way trademarks works and the way copyrights work. I've always viewed trademark as something like a big blanket that sort of fits over the entire product or service. In other words, that's the way people find their way to the product if they have used it before and liked it and want to go back and use it again, or conversely, if it was not a good experience, they use the trademark to stay away from it or to avoid it. And so this has the effect of blanketing the entire commercial transaction in such a way that I think frequently, if not almost always, it's very difficult in a litigation context to come forward and say, well, this percentage had to do with the trademark, this percentage had to do with other reputational factors involving the accused infringer, or whatever other factor they might be, the quality of the product without regard to what the trademark might have been. So let's compare what we just saw regarding the trademark statute with the copyright statute. Copyright owner is entitled to recover the actual damages suffered by him or her as a result of the infringement. and any profits of the infringer that are attributable to the infringement and are not taken into account in computing the actual damages. And then you go down a little bit further. The infringer is required to prove his or her deductible expenses in the element of profit attributable to factors other than the copyrighted work. Well, this makes it quite clear that in the case of a copyright, the statute understands that there are factors which can go into a profit number for the infringer that have nothing at all to do with the copyright. So copyright is more like slicing and dicing. And to take a couple of examples, take music. If someone infringes the lyrics of a particular piece of music, it's not reasonable to argue that you take into account what would have resulted in way of profits from both the music and the lyrics. They're in virtually every copyrightable work. There are ways that you can separate out certain aspects of the copyrighted work from other aspects. There are several cases involving magazines, for example, where owners of a photograph buried in the middle of the magazine came forward and took the position that, well, all the profits of the magazine belong to me because I had one photograph out of perhaps 40 or 50 in this magazine. Of course, it wasn't even the cover. So this is the type of thing that you very quickly get down into the weeds on when you're dealing with copyright, where ordinarily you really don't in trademark cases, and we'll touch on that a bit more in just a few minutes. There's also a question in copyright law regarding statutory damages. The way the copyright law is written is that under certain circumstances, and generally it involves when you've registered your copyright before an act of infringement took place over a certain relatively short period thereafter. If you have a difficulty finding any damages, you have a right to go in and ask for what are called statutory damages. Under the statute, these numbers start out fairly low, but end up being eye-wateringly large in some cases. And again, with cases under the patent and trademark statutes, constitutional issues were raised about the fact that copyright statute said that the judge would determine statutory damages. And the Supreme Court said, no, you have a right to a jury trial. So even no matter what the statute says, if you're going to ask for statutory damages, then you have to give that issue to a jury to preserve the substance of the common law right by jury. So in the Feltner case, which is about 20 years old now, the Supreme Court held that the Seventh Amendment provided a right to a jury trial on all issues pertinent to an award of statutory damages under Section 504C of the Copyright Act, including the amount of the statutory damages themselves. I don't think the statute, I'm not sure, I don't think the statute has actually ever been amended to comply with the Supreme Court ruling. It's just there. So we'll talk for a minute about a case, Alaura versus Cambridge. We represented Cambridge, the accused infringer. Alaura was a company in South Carolina that made its business, still does, designing and publishing architectural plans. Well, Cambridge bought one set of plans. It was an 8-unit condo, as I recall, and it came along with a license to use it one time. Well, what a defendant did, it used it to build several 8-unit condos. Alaura found out about it, clear case of infringement. They filed a motion for summary judgment and won. There was no doubt about the act of infringement. They took the position that the profits in the aggregate were about $900,000. And yet, at the end of the day, the jury awarded the plaintiff only $90,000. So the question is why? Well, our focus in this case was, obviously, these were building plans. So the focus was, well, what are the building plans? What's shown in the building plans? And how does that compare to the completed set of condos and based on the fair market value? So we looked at the plans. Well, that's a bare bones layout. There's Nothing in the plans about finishes, fixtures, flooring, appliances, lighting, landscaping, nothing, of course, about location. And our argument was to the jury that these were all things that had quite a bit to do with what the fair market value of the properties were, and therefore what the profits might be. And I remember asking the plaintiff's witness whether he would care to speculate about the value of these condos if they had been built next to a nuclear waste dump. And his answer was something along the lines of probably nothing. So again, in copyright cases, again, we get back to the whole issue of the jury trial. So there was a jury trial in this case, and the jury is the one that decided to award the $90,000 versus the $900,000. We did not purport to show in actual dollars and cents where that $90,000 came from. My approach was to politely, but nevertheless, ask rapid fire questions to the plaintiff's witness. What do the plans say about the finish, the fixtures, the flooring, the appliances, the lighting, the landscaping, the location? Without these fixtures and finishes and lighting and so forth, would the properties even been entitled to a building permit or an occupancy permit? The answer was no. Who made the judgments regarding whether these features or some other features would be selected for these buildings? Well, it wasn't Alaura. Under the statute, Cambridge had the burden to prove these deductions, which we did. So our argument was to the jury was by showing most of the profits were attributable to others' efforts. Although, again, we did not go forward and suggest to the jury that the number had or should be $90,000. I basically told the jury, use your own common sense. What are the facts in this case regarding what you see in the plans versus what you see in the completed dwellings tell you about what profits Alaura should reasonably entitled to recover. And the number was $90,000, and the client was quite happy with that. So Walmart versus variety stores versus Walmart stores. Here we get into a couple of issues about profits, damages, double recovery. Those of you who may have heard the talk I gave about a year ago may remember that this case goes back quite a ways now. Walmart, for reasons satisfactory to itself, decided to select and use a trademark that variety stores had owned for 20-some years. There was a lot of toing and froing inside of Walmart about whether or not to use it or not. There was an issue at one point about advice of counsel, which eventually we decided to avoid. But nevertheless, it was obvious that Walmart internally had decided a couple of times not to use it for legal reasons, and ultimately ran out of time and decided to use it anyway. So they sold over about a 3-year period, they sold $1 billion in infringing sales. The way the case started out, we filed a motion for summary judgment on infringement, and we won. The court also concluded that the infringement was willful. Somewhat to our surprise, the district court judge decided that he would hold a bench trial and had decided that he would not award any damages, but would limit his decision to how much of the profits to award. So I think it was probably 2017, we had a bench trial in Raleigh. The lasted, I think, close to a week. Evidence was that Walmart had made about $250 million in profits. And the judge issued a bench trial order a couple of months later, awarding Walmart Variety roughly $30 million out of the $250 million in profits. The reason was that, and I think the judge was simply wrong on this, the judge said that under the statute, it says that any award cannot be a penalty. And he came to the conclusion that any amount over $30 million would be a penalty. In fact, the case law is quite clear. The term penalty means that the number can't go above trebling, which is what the statute itself says can be awarded in a given case. So anyway, there were cross appeals. Walmart appealed from the grant of summary judgment. We appealed from the $30 million. The Fourth Circuit held that that there were issues of genuine issues of material fact that made the grant of summary judgment improper. So they vacated the award, sent it back for a trial. In October of 2018, we had a liabilities trial, and this time we convinced the judge that he had been wrong on not allowing a trial on profits, on damages, sorry. And so we had a trial where we put forward evidence both on liability and willfulness. The jury came to exactly the same conclusion that the district court judge had come to a couple of years earlier. They held that the infringement there was infringement and that it was willful. Then we showed up in again, Elizabeth City, North Carolina. It's an interesting place to try a federal lawsuit. In February of 2019, and put on a remedies trial. Same evidence, so $1 billion in sales, $250 million in profits. The jury awarded $50 million of the roughly $250 million in profits, and a 5% royalty on top of that. Remember, the statute says you get your profits plus any damages you can prove. And we argued that we were entitled to a royalty. So on the a little bit less than $1 billion in sales, 5% came to about $45 million. First of all, Walmart argued that was a double recovery. But in fact, they made no effort at all to prove any type of double recovery. The burden would have been on Walmart to show that they could not have passed that royalty along to the consumer. And if they had been able to convince the jury that, well, if we had to pay a variety of 5% royalty because of whatever competitive factors, we would have had to have eaten that 5% instead of passing it along. We would have, pardon me, we would not have, we actually would have reduced the profit award by a similar amount. That didn't happen, so so what Walmart has against them now is by the time you add interest, it's well over $100 million. Plus the district court awarded somewhere between $3 and $4 million in attorney's fees. As I mentioned earlier, all of that is on appeal, and because of all this COVID-19 drama, we really don't know what the status of the appeal is. The briefing was finished way back last December, and we're simply waiting now to see where this goes. Well, as far as, let me go back to profits. As far as profits are concerned, you remember a few minutes ago we were talking about the fact that there's no requirement under the trademark statute to prove that it was the trademark that resulted in the profits as opposed to something else. And again, I think similar to what we did in the Alaura case, we did not attempt to shove a particular number down the jury's throat. We simply asked the jury to exercise their common sense. They could award all the profits if they chose to, but to to think it over and come up with a number. That's the number they came up with. We'll never know why. I have my own speculations, of course. You probably do yourself, given the nature of Walmart as the one of the largest business enterprises in the world. Jury may very well have concluded that there were factors other than the trademark which resulted in some of those profits. Not unreasonable at all. So as far as the royalties are concerned, the key that we focused on here was making sure that we did not premise our argument regarding royalties on any single bit of evidence. We went out and found every bit of evidence that that we could find to build a case in the aggregate, which had several different points of relevance, any one of which, or more than one of which, the jury could rely on. So first of all, we did have evidence regarding royalty damages from Walmart. They had a history of licensing products in the same general category, including in one case barbecue grills. And we took us several motions to compel, and we had to drag the license agreements out of Walmart, but we did get them. And that some evidence of what those royalties were went into evidence. We also had the testimony of Variety's general counsel, Tim Blackburn, who had been Variety's general counsel for at that time about 40 years and had been involved in various intellectual property negotiations and disputes. And he simply said, in my opinion, anywhere starting at roughly 10% would be a reasonable royalty. Now, Walmart objected to that, but there's a case in North Carolina called Phelps versus Galloway, which is a case that that I tried probably 10 or 15, maybe 12 years ago. It was another building plans case, and it turned out very much like the case, the Alaura versus Cambridge case. Phelps, who was a local architect, Christopher Phelps, this case was tried in Charlotte, came in and wanted close to $1 million. It was a very large house built up on Lake Norman. The evidence was that he had sold the plans originally to a family on Lake Norman who had paid him $20,000 for the plans. And after all was said and done, that's exactly what the jury gave the plaintiff, $20,000. So the point being that Phelps v. Galloway, Mr. Galloway was allowed to testify because it was his house as to what he thought the profits were. And again, Phelps objected to that hearsay. Well, it's not hearsay because there's a rule in North Carolina, in state court and in federal court. This is a federal case here, of course, copyright. It says that the law indulges the presumption that an owner of property should be allowed to testify regarding what he thinks the value of the property is without it being considered hearsay. And so that's what happened. So we were able to bootstrap this was a Fourth Circuit decision, Phelps v. Galloway. We were able to bootstrap that ruling by the Fourth Circuit in our briefing in the Variety case. And I think it supports the proposition that Mr. Blackburn was properly allowed to testify. And as I sit here, I don't think that Walmart actually raised that issue in their appeal brief. I don't think they did. So in addition to Walmart's royalty damages and the testimony of Variety's general counsel, we also had a very good expert witness. In fact, it was J.C. Poindexter again, who was the expert in the Belmont versus Superba case. And again, he did a very good job of explaining to the jury in layman-like terms of why he came to the conclusion he did regarding royalties. And my hat's off to Professor Poindexter. He disagreed with Mr. Blackburn. He didn't think that 10% was a reasonable royalty. He thought that 10% was too high. He didn't say it quite that way to the jury, but we relied on his expertise and we didn't argue with him. He came to us and says, well, my analysis, looking at Walmart's own royalty numbers and my own general expertise, I think 5%, or at least starting at 5%, is somewhat more in the ballpark. And so we said, fine, if that's your testimony, go ahead and give it to the jury. And you have to believe, based on what the jury did, that they relied on Professor Poindexter's testimony. In addition, there's a book called Battersby and Grimes, and the title of it is something like Licensing Royalty Rates. You have to admire the ant-like persistence of these two gentlemen. This book is relatively thick, and it's mostly very detailed charts and tables of royalty rates categorized by various types of products, various types of product categories. A lot of this information comes from SEC filings. They glean it from published opinions. But anyway, we've used it several times. We used it in a trademark case a few years ago to establish a royalty rate. Judge Whitney allowed it in under Rule 803.17. We also got it in the variety case. Basically, what 803.17 says is that market reports and so forth are commercial publications, market quotations, lists, directories, and other compilations that are generally relied upon by the public and persons, in particular occupations. So that all came into evidence, and I think in the aggregate, it was very persuasive, and that's where it ended up. Now, as far as the attribution is concerned, we have to move ahead a little bit here. I think I just looked at my watch, and actually looks like it's 1:30. Hard to believe it's been going an hour already, but there are these cases, the Hamilton Brown Shoe Company, Mishawaka, and some of the others, that generally take the position that the burden does really have to be on the infringer to establish any deductions. And they say it's more consonant with reason and justice that the owner of the trademark should have the whole profit and that he should be deprived of any part of it by the fraudulent act of the defendant. And there's a concept called confusion of goods, where if you mix your own goods with somebody else's and you can't thereafter distinguish or separate them, you have to lose the whole. That's really sort of what's being said here. Here's another quote from the Mishawaka case. There are cases all over the place. Some can be justified on particular facts and circumstances. This case says that if it can be shown that the infringement had no relation to profits made by the defendant, then you shouldn't be able to recover it. But of course, the burden of showing this is on what they call the poacher. Another case says, well, it may be a windfall to the trademark owner, where it's impossible to isolate the profits, but the other alternative is to give a windfall to the wrongdoer, which you really shouldn't be able to do. Let's move along here. Equitable considerations. Down at the bottom, profits are awarded under different rationales, including unjust enrichment, deterrence, and compensation, particularly with regard to deterrence. If you're a willful infringer, you really have no equitable claim at all to be entitled to say, well, yeah, we infringed, but since these profits were allegedly the result of some other factor, we shouldn't really have to pay. That's just not the way it works. I don't think it's the way it really worked here. So let's quickly talk about some takeaways. To help establish that you acted in good faith, obviously written opinions of counsel are helpful. To help demonstrate you acted early in good faith, you might want to consider conducting patent clearance studies before introducing key products. Again, showing acting in good faith, responding to demand letters from patentees, you might consider asking the patentees for more detail and memorializing your non-infringement and invalidity bases, whether internally or in reply letters. And of course, at the given time, you're probably going to want to turn to outside counsel for written opinions to bolster your position. Licensing negotiations, you might want to obtain a written agreement with the patentee that licensing negotiations are not considered to be notice of infringement or evidence of egregious misconduct if licensing really doesn't work out. We'll get into this, the Patent Trial and Appeal Board. Sometimes people now bringing these actions in the TPAB, bringing a good invalidity defense in the PTAB may be evidence of a reasonableness of your defense. Now, some of the cases I mentioned, in fact, all the cases I mentioned, they're on PACER. And I would advise you, they're there for the taking. Belmont, Alaura, variety case. There are also several other cases, concept design versus Duplatronics case. Very, very interesting case that I handled a bit earlier than some of these others. Phelps v. Galloway case that I mentioned. Also, we just concluded about 6 months ago a case in the Northern District of Texas. We represented Firebird's Wood Fired Grill here in Charlotte against Firebird's Restaurant Group in Dallas, which turned out quite well for us, I think. I think we finished more or less on time, 1:36 p.m. I didn't get any questions, but again, I'm easy to find. Feel free to look my phone number up or my email address. I'll be happy to talk to you or exchange emails about any questions. Again, you can go on Pacer very easily. All this information, these briefs, and I think a lot of the work we did and a lot of the work that our opponents did was all excellent work. It's there for the taking, so I would encourage you to make use of it if you think it would be helpful. With that, I appreciate your attention. I enjoyed giving this presentation, and I hope you all found it useful. Thank you very much.